All right. Welcome, everyone. We are live. Welcome to the Ad Hoc Commission on the Discipline System Diversion Working Group. I will take the role at this time. Michelle Anderson, I do not see her. Karen Bell.
Here.
Shanae Buffington, I do not see. Jenna Jones, I do not see. Alexia Mayorga.
Here.
Steve Moad.
I'm here, and I see Shanae in the attendees list. She may need to be promoted.
Let me move her. Thank you for seeing that.
Of course.
There we go. Okay. Shanae, can you hear us?
Yes, good morning.
Okay, good morning. Welcome. And then Ellen Pansky, I do not see. But we have a quorum. At this time, I would like to call for public comment. I don't see any members of the public at this time. So I think we can skip to the presentation and the discussion. Let me begin to share my screen. So hopefully everybody can see my screen. Welcome to the Diversion Working Group. The agenda for today is very similar to what we've had in previous days. We're going to kind of have a discussion on the scope for the working group, and then what exactly we're trying to accomplish, and then what we need to accomplish those goals. Are there data requests, are there research requests, are there presentations that the working group would like to further those goals and get us to recommendations? As a quick history, we talked about several different things with this working group. It was part of the effectiveness subcommittee, and this is where we discussed the diversion. We talked about it in a criminal context. So we talked about the recently passed legislation that qualified a lot of misdemeanors for a diversion program, where if you successfully completed that diversion program, the charges were dismissed. So it was pre-trial diversion. We also talked about agreements in lieu of discipline, ALDs that OCTC currently has, and they are not considered discipline because they are non-disciplinary. It's prior to discipline, but it's the highest level of offense before you get to discipline. And there are certain requirements in that program. And then we also talked about the alternative discipline program that the State Bar currently provides. As a brief reminder, I'm not going to go into too much detail, but the agreements in lieu of discipline, like I said, they're non-disciplinary. They're usually result in directional, resource, or warning letters, and they require an ongoing action from the attorney. So ethics school, quarterly reports, reviewing the rules of professional conduct. But again, these are all prior to discipline. So it's similar to a diversion program in the fact that you complete some task and then the charges are dismissed. It is dismissed. There's no record of discipline. And so this is something that the State Bar currently does, and this working group may want to look into expanding that, or not expanding it, but just review it in general. The alternative discipline program, as a brief reminder, is something for attorneys that have a substance abuse or mental health issue. The parties, so OCTC and the respondent, must enter into a stipulation. You must be accepted into the lawyer assistance program, and the lawyer assistance program is the State Bar's program for attorneys that have substance abuse or mental health issues. And that program has weekly group mental health meetings. They have drug testing. They have various requirements, evaluations, inpatient, outpatient treatments. It's tailored to the respondent, but there are certain requirements to participate in LAP. And in order to be in the alternative discipline program, you have to be in LAP. And then you also have to show a nexus between your substance abuse and mental health issue and the misconduct that the discipline resulted from. So it can't just be that you have a mental health issue, it's the mental health or substance abuse issue led you to the misconduct. There are 2 levels of discipline. So this, if you successfully complete the alternative discipline program, you get a lower level of discipline. If you are unsuccessful, you get a higher level of discipline. So it's not, the discipline isn't discharged like in the misdemeanor criminal context. So I just wanted to provide a brief update on that. I will stop sharing. And so now I would like to have kind of a conversation. And I noticed, Jenna, you have joined us, so welcome. In the true diversion context, we had the presentations on the different types of collaborative courts, mental health court, substance abuse court. They even had some veterans VA courts. They have homeless prevention court or homelessness courts. And we also talked about the assembly bill that allowed for misdemeanors to go into diversion programs, but they're focused on the effectiveness subcommittee, kind of looked at the alternative agreements in lieu of discipline, and then also the ADP program. So in terms of where this working group would like to focus its efforts, are there thoughts by the working group members on areas of focus for this? And I can say that as a recollection, the alternative discipline program was talked about. There was talked about the history of the alternative discipline program where it originally had allowed more respondents into it. And then at some point, the decision was made to kind of restrict who was eligible for that program. And the subcommittee seemed to be interested, and I would think that this working group would be interested in reviewing that change and why that change was needed at the time and why that change was adopted. And then also, I think there was a presentation on recidivism to kind of see the effectiveness of these different programs. I know Ron presented, I think he had more recent data on the agreements in lieu of discipline and the relatively small recidivism rate for those agreements, but I don't think we necessarily had current information on the alternative discipline program. And so there was kind of a discussion at the subcommittee at that time to see whether or not just review the changes that were made in the alternative discipline program and whether or not they needed to be revisited, whether or not it was effective. So I remember that thorough discussion and I'm seeing a nodding by Karen that would probably be something that this working group would like to look at. So Karen, I will call on you.
Yeah, I mean, I got the sense that there was a staffing piece of it as to why that it was burdensome, I guess, to run the program the way it was run before, if I'm remembering the discussion correctly. So I don't know if that was part of it or if that was just an aside, and the reason why the change was made to make it more restrictive was more of a philosophical. I'm not sure, but I definitely am interested in learning more about why the change was made and, exploring what it would take to make the program be more expansive if it's working. And I mean, I think maybe that's the data piece is like, what is the recidivism on that? What kinds of issues are, when is it used? I guess I don't have a sense of like, especially that idea of when is the behavior connected and how you prove that? Like, does that turn out to be a really sticky issue? Does it make sense to have that? I don't know. I mean, I just don't know what the philosophy was of making it in that that way. I guess, I mean, I understand to a degree, it's like, okay, well, this person has a mental health problem, and we want to recognize that, and we want to help them fix that. And if what they've done is not so terrible as to require disbarment, then better that we should help them get past their mental health or addiction issue, and then we can, they can be a functional member of the bar. And I think that's great. I completely agree with that, but I'm just not quite sure how it all works in practice. And I definitely am not sure what the change was and why it was made. But I'm definitely interested as well in the agreements in lieu of discipline. And forgive me for not remembering the entire discussion. First of all, thank you for grounding us in a little bit of a summary of what we talked about before, because these meetings, it's a few weeks between and you just don't remember. And so I'm sorry if I'm not remembering everything, but my thought on the agreements in lieu of discipline is that, I think it's very much in line with the idea of, really improving people's knowledge, skills, et cetera, because we're giving them something. We're saying, okay, you messed up, but it's something that can be cured. It certainly can be fixed going forward, and we don't want this discipline hanging over your head forever, because as people have noted in this commission and elsewhere, that once that discipline's on someone's record, it's really life altering. It is career ruining in many respects. And so if we're going to do anything seriously about trying to make this whole thing more fair, it seems to me that avoiding discipline on people's record is really an important part of it. So it seems to me that the agreements in lieu of discipline, I'd like to spend more time on it for sure, understanding how it's being used now, if it could be used more. I'm sure people that are more involved with it have their ideas about whether it's already sort of at its maximum, or if it is an area where there could be more done, because it just seems like it's the best outcome for someone who wants to, protect their reputation in their career, because we've talked about kind of how hard it is to get this stuff off your record. It sort of stays there forever and those kinds of things. So anyway, I don't know, I guess that's just my goals of what I hope we can focus on, but I'm not quite sure step by step how to get there. So maybe someone else can speak to those issues or reflect on anything that I've said. So thank you.
Thank you, Karen. Anybody else? We can get a presentation on the changes to the alternative discipline program. I think at the time, the thought was that too many people were eligible and that it was too expensive and there was too much. And so the thought was to kind of restrict it, because the outcomes weren't what was originally intention, I think is what they thought. But we can get a thorough presentation on the changes and why they were made. But I think it was originally that there was too many people participating, and so they wanted to narrow down the focus. And then in order to actually do a true evaluation and see whether or not any changes need to be made to expand it or offer it to other people, we should see the effectiveness of it. And that's where the data request comes in, as the recidivism and that kind of thing. So I definitely have those two notes. We had a presentation on the agreements of lieu of discipline, but I think that's a good discussion. We can kind of get a presentation on that. And if there is any potential expansion or other alternative uses, maybe there's something outside the box. And we can get OCTC's thoughts on that at a future working group meeting as well. Shanae, I see your hand is raised.
Yes. So we just had our working group meeting for closed complaints. And I know there was some discussion regarding, if a complaint is filed and it's turned out to be unsubstantiated, that possibly notice can go to the attorney about the closed complaint. And then the attorney would have I don't know if we talked about it being mandatory or not, but the attorney would be notified, possibly attending like an MCLE or training to prevent any possible future misconduct. Is there like some crossover, what we're talking about here, Mr. Ewart, and kind of what we discussed in our closed complaints working group last week? Yeah. As it relates to diversion?
I see similarities. Yes, I see, because some of the agreements in lieu of discipline are resource letters, and we're talking about in the closed complaints. Maybe I think it's a step below ALDs, but it is definitely similarly themed, where you're trying to get information and trying to be preventative in the actions. So I see Steve shaking his head, so I'm not too far off the reservation on that.
No, that's correct. We have resource letters, we have warning letters, we have agreements in lieu of discipline. I would say that they are all, in some sense diversionary, in the sense that they don't go through the discipline system, but they're somewhat different. And we really would use an agreement in lieu of discipline where a warning letter is really not appropriate, that there is evidence of a violation, but the violation is relatively minor. There's substantial mitigation, which outweighs any minor aggravation that there is, things along those lines. So it's going to tend to be not a serious violation, because ultimately we have an obligation to move the case forward to protect the public and the legal profession. And so if it is a serious violation, it's probably not something that we would tend to use for an agreement in lieu of discipline.
Okay, understood. And so then when you say it's a minor violation, do we have a list of minor violations or mitigating factors?
We have a list of mitigating factors. We have a list of aggravating factors as well. Those are in the standards for attorney sanctions for misconduct. I don't know that we have a list of minor violations. I still check, but I don't know if we have a list. I think we have a.
So if we're sending out, you said I believe you said a resource letter. A complaint has been filed with the state bar before. Is that correct? Is that how things kind of get initiated?
Yes, either a complaint or we receive a reportable action, or it comes to our attention in some other way. It may be a state bar initiated action. Maybe we read about something in a newspaper or hear about something in some other way. But yes, more generally than a complaint is filed, it comes to our attention by one way or another. So will this working group be tasked with possibly coming up with the list of minor violations, where it would be appropriate for, I believe you said a resource letter to be sent to an attorney, or is that discretionary for OCTC to determine what's a minor violation? Or
I think that where this working group might just review, because I think we can get like a sample or examples of what's typically in these would require a resource letter be sent out. I don't know. I'm not speaking for Ron or Lisa, but I can imagine that there's some way we can mine that data. And I don't know. It would just be a review of that to see if it's appropriate. And then I guess we could also take input from OCTC if they think that there's potentially a more effective, or if the working group members say, well, what about, it's open to a discussion if there should be any changes made to that, or if they want to make recommendations to the changes to that resource letter, or what's eligible for the resource letter. Karen, I see your hand. Oh, sorry, Shanae, are you finished?
I am, sorry, thank you.
Okay. Karen.
Thanks, yeah, just to kind of follow a little bit on what Shanae was asking, because I think those are really good questions and I would like the answers to those too. And who is it that decides whether if there's not a list, so it's not a cookie cutter thing, it's more of a discretion, who decides and what process is there, on that to calibrate or to kind of, ensure consistency or, non-discrimination in that process, who makes the decision about whether something can go to an agreement in lieu of discipline?
I don't know if you're asking me or Justin. I guess from my part, it's the prosecutors in the Office of Chief Trial Counsel. Part of the issue is that some of these things, they're not cookie cutter, as you put it, and it's hard to classify. I mean, you're really looking at what, like I said, minor offenses, whether significant harm occurred as a result of the conduct, and then the sort of analysis of mitigation versus aggravation. And there is inherently some discretion in that. You're absolutely right.
Thanks, Stephen. I think maybe that's why, going back to Justin, you were saying, I think that we could get some examples maybe of where they've been used. And I think it'd be helpful to know kind of some examples of where it was requested or proposed, but it was rejected, so that we know kind of where the lines are currently being drawn. And especially because when you're looking at conduct, that maybe one person engaged in conduct and then another person engaged in the same conduct, but through kind of the luck of the draw or the universe decide, that significant harm occurred in one case and not the other, even though the conduct was the same. I don't know. Are the prosecutors looking at that and trying to be consistent? It's just, there's all the idea of bias coming into a system where there's a lot of discretion. And I'm not saying that anyone's doing that intentionally or that there's not an effort to be consistent, because I'm sure that there is, but just, being involved in employee discipline for 30 years, like I've seen, how these issues arise. And, obviously this is the concern that we're meant to address as this committee. So hopefully we can get a little bit more information, because I think it's when we delve into those details is when we're going to kind of be able to really have better ideas about how to improve, if there's room for improvement. I don't know, but if there probably is, because there usually is. And I think it's when we really delve into those details of particular cases is when the issues just become more clear to everyone. At least that's how it is for me. So thank you.
Justin, did you say that this was a creation of the fairness or the effectiveness subject?
Effectiveness.
Okay. And that's certainly not to say that we can't consider the things that Karen was talking about, but I just also want to make sure that we are addressing sort of the effectiveness, efficiency piece, in addition to looking at any other fairness related topics.
Yeah. Okay. Anyone else on the working group have thoughts? I think that the discussion to this point has provided us with the direction and clear objectives in terms of what we need research-wise, what we need to present wise, and also a couple data requests, which Oriah has done a marvelous job to this point to bring back to the working groups. Are there any other questions or thoughts by the working group members? I don't see any hands raised. So I will circle back with Lisa and Ron and Dag to see how much time, because we're juggling 7 working groups right now. So the data requests are significant. And so we're trying to align them up. And once I get a better idea of when we can get the data and then the presentations for this working group, I will send out a doodle poll to gather everyone back together. So I really appreciate everyone's time this morning. And unless anybody, Dagron or anybody, Lisa, has anything else to say, I think we can adjourn. All right. Thanks, everybody.
Thank you. Bye.
Thanks all.